They don't know either. So.
How they doing? So
Hear me okay?
Yes, sir.
All right, we've got everybody connected, so we'll go on the record in People versus William Butz, case number 246743. Record should reflect Mr. Butz is appearing today by video from Otsego County Jail. I can have counsel put your appearances on.
Good afternoon, Your Honor. For the record, Mike Roll on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Butz.
All right, we're on the record here today. Bench warrant was issued back near the end of January for Mr. Butz' arrest, I guess, January 29th, alleging that he violated his bond by consuming alcohol on or about January 25th. And Mr. Trush, have you been appointed in any other matters to represent Mr. Butz?
I am. I represent him on the underlying matter. I also represent him on two pending probation violations in Crawford County that stem from the same allegations as the underlying charge.
Okay, and that's the basis for this bond violation as well, is that correct?
Well, I mean, the violation, it's the bond that, so he's alleged to have violated the bond for the new charge, yes.
Right, okay, gotcha. All right, have you had a chance to speak with Mr. Butz about this portion of his matters?
I did, and I was able to go over with him that he's entitled to have a contested hearing on the bond violation, but I believe it is his intentions to admit that he consumed alcohol.
All right, Mr. Butz, is that correct?
Yeah, I did, Your Honor. I'm not gonna lie. I got jury trial going on for another case that I'm trying to beat. Me and the old lady went out and had a drink with dinner.
Hold on. But the judge has to put you under oath and stuff first.
Okay, I'm sorry.
Mr. Butz, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Butz, you were on bond in this case. Is that correct?
Yep.
Were you aware that one of the conditions of your bond was that you were to not consume any alcohol while you were on bond?
Yes, sir.
Okay, and you just indicated that on or about January 25th, you did consume alcohol in violation of the conditions of your bond?
Yes, sir.
Okay. Based on that testimony, the court finds that there is grounds to find that Mr. Butz did violate his bond as alleged in the bench warrant. The bond was revoked as part of that bench warrant. I believe Mr. Butz is still entitled to have a new bond set. Obviously, it's going to take into account the fact that he violated his bond in this case. So I believe the previous bond was a $5,000, 10% bond. Mr. Rolla, on behalf of the people, do you have any position with regard to the new bond in this case?
Judge, as the amount of bond, I'm gonna leave that to the court, but I do believe now that 10% is no longer appropriate, as the court's already issued a 10% bond, and the defendants indicate clearly that's not sufficient to get his attention. He's out on bond. He's committed another violation. Thank you, Your Honor.
Your Honor, I've never had a.
Well, go ahead. Well, Mr.
I've never had I'm sorry. I don't know. I've never had a probation violation. I've been on probation for 3 years. I'm full-time parent with my daughter. I'm not trying to make up what I did was wrong. I've already admitted what I did was wrong. I got a very great employment job. I work at MEC, at Unipro, and Vanderbilt. I understand what I just need to get out to my daughter, please. I'm the only full-time parent. I don't want to lose my job. I know what I did was wrong. I mean, I'm trying really, really hard here. I haven't had no violations, no nothing. I just got a lot going on with the new court thing coming up. I mean, I'm sorry.
All right, thank you, Mr. Trush.
Thank you, Your Honor. So I think it's important for the court to recognize Mr. Butz has been on bond for, I think, about 8 months in this file. This is the first alleged violation of the bond. In addition to that, the court could even kind of take notice that he's been on supervision longer than that because he had the probation out of Crawford County, which again, I think the new charges were the first alleged violation of that. I would suggest to the court, there should be a response to it. I think that is appropriate. I would ask the court, not to have a response that's too heavy-handed. I would suggest to the court that an appropriate bond might be 10,000, 10%. That would effectively double the bond. That would seem appropriate given the specific allegation here.
All right, I agree with the prosecutor that a 10% bond is not appropriate, given the nature of the underlying charges here, given the violation, and that the violation resulted in apparently some additional criminal charges. The court is going to set bond in the amount of $1,000 cash or surety. And I believe that we currently have next date already scheduled for a final status conference on March 17th. So that date will remain in effect. And we'll go forward from there. Mr. Roll, anything further we need to address for the record today?
Not from the people, thank you.
Mr. Trush?
No, Your Honor, thank you.
All right. Okay, thank you. That's all for this hearing today. All parties on this case. Yes, Mr. Butz.
So how much is my bond, sir?
$1,000 cash or surety.
Okay, so $1,000. Thank you.
So you'll want to get in touch with the bondsman.
All right, thank you.
Okay. All parties are free to disconnect at this time.
Thank you.
Okay, we have counsel connected. We'll go on the record in Trevor versus Northern Food Group. This is file number 2319554. If I could have both counsel put your appearances on.
Good afternoon, Your Honor. Elliot Blumberg on behalf of Mr. Trevor, who's appearing via Zoom from my office.
Good afternoon, Judge Paul Slough on behalf of all the defendants.
Thank you. This is set for a status conference today. Looks like the last time we met was back in November. The parties were going to undertake a business valuation, and then we set this for a status conference. Mr. Blumberg, on behalf of plaintiff, can you tell me the status today, please?
Sure. Atomy Business Valuations of Grand Rapids has been retained by Mr. Trevor. They are in the process of putting together and finalizing their business valuation of Mr. Trevor's interest in Northern Food Group, LLC. There is outstanding discovery that we owe Mr. Slough that we are working on, and we hope to get that to him fairly soon.
Okay, thank you. Mr. Slough?
I don't have anything to add. I mean, that's true. The discovery is outstanding. It's not due till, I think, Wednesday. And if you need more time, Mr. Blumberg, just let me know. But yeah, we would anticipate, reviewing the discovery responses and the valuation report and then proceeding from there. And until we see those things, we don't really know which direction we're going to go in this case.
Okay, I know the parties already did participate in mediation. Is that something that either of you are contemplating going forward, or should I just look at getting some trial dates, Mr. Plumber?
Well, unfortunately, Judge, the operating agreement, which seems to be the main document in this case, talks about a third business valuation in the event. Well, and I'm not even sure what the contingency is, and that once the second business valuation is completed, it calls for the creation of a third. So maybe Mr. Slough has some thoughts about that.
Well, that's true if the two valuations don't agree. Then the two evaluators then pick a third. They agree on a third evaluator to make a final dispositive determination of the fair market value of the business. It's a mechanism in the operating agreement to break a gridlock, deadlock between the members. I'm certainly open to mediation. If the court will recall, there's two issues here. One is the valuation of the business. The other is this alleged misuse of some credit cards. And that's part of our written discovery requests is trying to get more information about those transactions and the circumstances surrounding them. Once we have that information, we may be open to some mediation. But again, I got to see that information. And depending on what the response is, we may also just want to file a summary disposition motion on those counts. So it's going to be really one of those two paths, I think.
All right, I guess maybe what we should do then is set this for another status conference, maybe 90 days out, see where the valuations come in at, and what that leads each party to in terms of their position for how they want to go forward. Any objection to that, Mr. Blumberg? No,
that seems reasonable.
Mr. Slough?
I don't have any objection to that, Judge. I would only ask that we get some documentation from Mr. Blumberg's client that this valuation is being done and that it's going to be completed by some estimated date.
Well, I can certainly give you the receipt for $7,500 that they charged him. So yeah,
that would be good. I just like to be able to show my clients something that because this case has been pending now for a while. So I just want to be able to show my clients that we're moving forward here.
I mean, certainly any delays that it's taken to get this taken care of is the fact that he's been removed from his job and his investment, and he's had to come up with a significant amount of money to retain this firm to do the work. So, I mean, those are the realities. I'll send you whatever we have that shows that he paid $7,500 in the form of a retainer to Atomy business valuations of Grand Rapids.
Yeah, and I mean, is there anything that would prevent, Mr. Slough, that would prevent you from contacting that evaluator and getting updates from them? I mean, is there any kind of confidentiality that would go along with that?
Yeah, I think the evaluator would be apprehensive to speak to me representing another party in the litigation. I think it'd be more appropriate if Mr. Blumberg's client and he just turn over that information to us rather than me trying to contact their expert.
Okay.
Yeah, I don't think it would be appropriate at all, Judge, frankly.
All right, so I think, you know, some kind of letter confirming from the evaluator that they've been hired to conduct this evaluation, or a bill. You know, I think either of those would be appropriate to confirm for Mr. Slough's clients that they've been hired and they're actively engaging in conducting that.
That would be fine.
Okay. All right, so I'm just going to have discovery to remain open, business valuation ongoing, set for status conference at 90 days. Mr. Blumberg, anything else I can address for your side?
No, I don't believe so.
Mr. Slough?
Nothing. Thank you.
Okay, thank you. That's all for this case. And Mr. Blumberg, if you want to stay on the line, I've got Ms. Mott here connected for the next status conference as well.
Thank you. This won't take long.
All right, Ms. Mott, are you able to hear me?
I am. Good afternoon.
Good afternoon. We're on the record in Greif versus Advance Electric, file number 2419731. If I could have counsel put your appearances on.
Good afternoon, Judge Elliott Blumberg on behalf of the plaintiff.
Catherine Ma on behalf of the defendant.
Okay, this is set for a status conference in this file today. Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at with this file?
Yeah, Judge, the parties have come to a resolution to this matter. I've been provided a copy of a settlement document that I'm about to go through with my client. And I think we can report to the court that this case is resolved.
Okay, Ms. Mott?
I agree.
Okay. Mr. Blumberg, any time frame on when we can get a dismissal?
I would think within 14 days at the latest.
Okay.
And Elliot, I did send you a draft stip in order as well as the agreement. Okay,
I received that. Yep.
great.
Okay, great. Thank you. That's all for this file. Then both parties are free to disconnect.
Thank you.
You may have another one. Hold on. Yeah. Oh, that's in this report. Okay.
Mrs. Lesnick, are you able to hear me okay?
I can. Good afternoon, Judge. How are you?
Good, thank you. Good afternoon. I am just waiting for Mr. Blumberg to connect, so if you can just hold for just a moment.
Will do.
Okay, looks like we have both counsel connected. We'll go on the record in Casper versus Casper. This is file number 2419733. If I could have both counsel put your appearances on.
Yes, thank you, Honor. Jennifer Zalesnik appearing on behalf of the plaintiff, Rebecca Casper.
Good afternoon again, Judge Elliott Blumberg on behalf of Mr. Casper, who is appearing via Zoom from my office.
Okay, thank you. This is set as a status conference today. Just looking through the file, the court had previously ordered mediation, which I think was delayed due to Miss Casper having new counsel. So just kind of want to get an idea of where the parties are at, if you've been able to have any discussions and what both of you want to see going forward for scheduling. Ms. Zalesnik on behalf of plaintiff.
Thank you. Yes, Your Honor. I do not believe that mediation was delayed on part of Ms. Casper retaining alternative counsel. In fact, when I was retained as counsel, it took me a little bit to get the complete file, but once I was able to get the complete file in reviewing that, I noticed that Mr. Blumberg had not completed and served the response to the discovery request that was served in September by Ms. Casper's former counsel. I have since, unfortunately, found it necessary to file a motion to compel. That is scheduled to be heard before you on February 18th. I'm not sure if the court's received that yet. The biggest delay is just that Mr. Blumberg hasn't provided documents necessary for us to even negotiate any type of settlement, whether it be between counsel or at mediation. So I'm just I'm asking for attorney fees because I put quite a bit of effort to communicate with Mr. Blumberg about the discovery responses. And there is nothing in that discovery request that is overburdensome. And so we're asking for values and documents to verify the values. And that should be like produced in, I would say, less than 24 hours because it is causing a delay. And I mean, if the court is inclined to have my motion hearing I'm fine, but I really need that in order to proceed forward with mediation. And also, we were going to have mediation scheduled February 8th. But Mr. Blumberg did not want to proceed with mediation on February 8th. Because no, I'm sorry, it was before then. It was before our hearing. I can look back, but I did communicate with the mediator and there were some dates of it, and I think it was February 8th, but Mr. Blumberg did not want to proceed with mediation on that date. And I was like, it was because he was saying that we can't resolve the child related issues, and I really don't know why he didn't want to proceed with mediation, but I was inclined to proceed with mediation with even limited documents because I just need to get verifications of amounts. And I think those are things that could certainly be produced during a mediation.
All right, thank you,
Yeah.
Mr. Blumberg.
You know, Judge, I'm sitting here listening to this person make these statements to the court today that are baseless, that are wrong, and I take offense to it. I mean, the fact of the matter is the major asset of this marriage is the marital home that needs to be appraised. I asked predecessor counsel, would her client be willing to split the cost of an appraisal? The answer is no. I've had no communications with Ms. Zalesnik about this matter. Any discovery that's been sent will be answered. If she needs to file a motion to compel rather than calling me and asking me when we can have the answers, you know, that's how she wants to operate. But I refuse to sit here and listen to these misrepresentations. I've been in front of you all day today, and I've never had another attorney speak like this woman has done. I take offense to that. I want the court to know that.
Okay.
Your Honor, I'm happy to show my emails where I've tried to communicate with Mr. Blumberg. I don't want to go back and forth like toddlers in the sandbox, but good Lord, Judge, I have tried to work this out with Mr. Blumberg to no avail, which necessitated me filing this motion. I very rarely file motions to compel, not very many times, but I can show you but I don't know that this is the appropriate forum. I think that the appropriate forum, number one, for my motion to compel is the February 18th hearing. What I'm telling you is not baseless, and it's inappropriate for Mr. Blumberg to state that, but I am happy to share my screen with you and go through the countless emails that I've had with Mr. Blumberg, trying to get mediation scheduled, trying to get the discovery response, all of the communication that I've had with Mr. Blumberg thus far regarding the discovery request and the response has been attached as exhibits to my motion. So you will see my efforts.
Let's deal with it at the motion, okay? This is a status conference.
He asked why there's a delay. And you said you haven't spoken to me about mediation, which is false, Mr. Blumberg.
What I said was mediation would not be productive without an appraisal of the marital home. And your client and you have refused to participate in the expense of that.
You've never even talked to me about it.
Sure, okay. Anything else we need to talk about, Judge?
All right, I think what we should do is go forward. Ms. Zalesnik, you already have that noticed up for hearing and it's on the docket.
Yes, Your Honor, on February 18th.
Okay.
At 10:45 a.m.
Okay, so let's go forward with that motion. Let's see what the result of that is. It sounds like that's information that would need to be disclosed if it hasn't been, and if it's appropriate for purposes of mediation and for that to be successful. So let's go forward with the hearing. I'll set this for another status conference on the same date as the hearing on the motion to compel. And I'll just ask counsel in the meantime to try and have some discussions that are a little less rancorous so that we can move forward with the case. And if not, then we'll have a ruling on the motion on the 18th and we'll go forward from there. So that's all for today. And we'll counsel.
Judge, are you going to put a deadline on I mean, I really would like to get a deadline on mediation if there is a possible way.
we'll address that at the motion hearing, because if you're saying that you need those documents to be able to go forward with mediation, then I think I need to rule on the motion to compel. Because if I rule in favor of Mr. Blumberg on that, then that may affect the deadline for mediation. And if I rule in favor of you, that may affect it as well. So I think we need to get that taken care of. And on that date, depending on which way the court rules, we'll set a deadline for mediation.
Judge, can we
Thank
address the issue of the appraisal of the marital home? Or is that for another day?
Well, I mean, if you guys are either gonna agree to split it or you're not, and if you're not, then I suspect it would have to be the subject of a motion, or one party pays for it and asks for half of it as part of the judgment. I think, you know, absent some other circumstances, I think the default position is the parties would split the cost of it. I don't see why they wouldn't. Maybe there's a good reason why they shouldn't split the cost of it. And again, I think that would have to be the subject of a motion. Well,
I don't know that it's not, I don't know that it's the position of my client not to split the motion, but she is covering 100% of the costs of the house at this point in time per that order that was entered in the court prior to me being involved. But I don't know that she has the financials in order to do that, but I can certainly check with her. This is the first time that Mr. Blumberg's ever mentioned splitting the cost of the appraisal.
Okay.
I don't even know who he's wanting to use, but I think an appraisal needs to be done so that we get a current value.
Okay, so again, I mean, these are things that normally council can work out.
Yeah.
I would ask you again, in the spirit of some cooperation, try to get past this hearing and work together. If you can't, then we'll have to have more motion hearings in front of the court to have the court order how those things will happen. So either way, none of it's noticed up for hearing today. Mr. Blumberg's right, it's supposed to be a status conference. I anticipated just setting some dates. So that's what we'll do. We'll go forward with the motion hearing on the 18th. The court will set a mediation deadline on the 18th. If any other motions are filed and notice for hearing between now and then, we'll address those on the 18th. Otherwise, they'll have to be set for hearing on a different date if there are matters that council can't agree on.
Thank you.
Thank you,
Okay,
Judge.
thank you. You're both free to disconnect at this time.
Thank you.
Judge, I think I have one more. Am I next or should I come back?
Is that the Glazer matter?
Yeah.
Yep, okay, yes, do you have Miss Glazer at your office?
Yeah, she's here in the waiting room.
Okay,
When did you send her in? Yeah.
Mr. Glazer, are you able to hear me okay?
Yes, Your Honor.
Okay, do you have Miss Glazer there, Mr. Blumberg?
Yes, I do.
Okay, we'll go on the record in Glazer versus Glazer. This is case number 2319311. The record should reflect that Miss Glazer is present along with her counsel, Mr. Blumberg, by Zoom. Mr. Glazer is also present by Zoom. This is set for a status conference hearing today. Mr. Blumberg, can you tell me where things are at from your side of things?
Sure, Judge. Again, Mr. Glazer is currently unrepresented, which has complicated the case a bit. Some of the delay attributed to getting this case resolved had to do with the valuation of Mr. Glazer's business, which he has now informed me has been dissolved. So given the status of that, it would appear the only way we get this matter is resolved is by trial. And so, Judge, we would be respectfully asking your court to set a trial date in this matter. We would think it can be done in a single day.
Okay, has there been mediation yet, or do you feel that mediation would not be helpful, or what's your position on that, Mr. Blumberg?
Well, I think early on we had a mediation, but that was when Mr. Glazer was operating a business. So we haven't gone back to try it again. I don't know if the court feels it would be appropriate to go back. I mean, I don't know. I don't know how to resolve this matter at this point.
Okay. Mr. Glazer, can you tell me what your position is as we stand today?
Last time we were in front of your honor, yourself, your honor, the mediation has reached out to me and I said I was available for whatever. I'm not saying that mediation would answer any problems because like Mr. Blumberg said, they wanted to come after some of my business. What there is no business. So I don't know. I spoke with Mr. Blumberg and kind of told him what I thought was somewhat of a fair, my feelings of a fair separation arrangement of this marriage, and I would assume that was shot down. I guess I don't know. I haven't heard otherwise. I'm just this is drug on for almost 2 years now.
Yeah, okay. Mr. Blumberg, did you say half a day or 1 day? I'm sorry.
If Mr. Glazer is unrepresented, then we probably could do it in a half a day. If he were to retain counsel, then I suspect it would take a day.
Okay. All right, I'm going to set this for a half a day bench trial. I agree. I think both of you are indicating we just need to get this set for a hearing and get it resolved. So I'll set it for a half a day bench trial. Mr. Blumberg, is there any particular time that you need in order to be ready for that?
I think 30 days because I got to get the appraiser subpoenaed and, to get all the documents necessary. Yeah, so outside of 30 days would be fine.
Okay, Mr. Glazer, is that enough time for you to be ready?
Yeah. Yes,
Okay.
sir. Yes, Your Honor.
All right, and Mr. Glazer, are you intending to proceed without counsel?
That's correct.
Okay, so I just want to make sure that you're clear. I can't give you legal advice. I can't act as an advocate for you and tell you what to do or how to do it. So you may want to consider, at least consulting with an attorney. But the date of this bench trial, that's going to be the date that the court takes any evidence that there is regarding assets and debts of the parties, and the court will be making a decision on how to divide those things up. So that's going to be a really important day for you to be ready with any documentation and other things that you're going to need to present your side of the case here, okay?
Yeah, okay, Your Honor.
So again, to the extent you're able to, I would encourage you to seek some legal advice as to how to proceed so that you can adequately represent yourself if that's what you're going to do. The court will send out notices to each of you for the date and time of that hearing. That will be, because it involves the taking of evidence, it will be an in-person hearing, so everyone will be required to be here in the courtroom for that hearing, along with any witnesses you may have, unless there's an agreement to do it remotely. Mr. Blumberg, anything else I can address for your side today?
Judge, just that I will continue to reach out to Mr. Glazer to see what we can do to try to resolve this in advance of trial.
Okay, thank you. Mr. Glazer, do you have any questions at all?
My only question, Your Honor, is my court paperwork has been being sent to an old address. Is that something that I could handle right now, or do I need to contact the clerk, or how do I handle that?
I don't want you to put that out there now because this is a public hearing and I don't know that you want to put your address out for everybody to hear. So
sure.
You can call the clerk's office, but yeah, if you're not getting mail, then you should definitely call to make sure that we have the correct address.
Absolutely. I appreciate it, Your Honor.
Okay. All right. Thank you. That's all for today. And you're both free to disconnect. Okay, council, it looks like everybody's kind of getting signed on here. Okay. I think I have everybody connected, so we'll go on the record here. This is Kent Family Farm versus Vaughn. Case number 2419708. And if I could have defense counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Judge Paul Slough on behalf of plaintiff Kent Family Farms.
Good afternoon, Judge Melissa Pranzalis on behalf of defendant Mertz.
Jeff Shimovitz on behalf of Ben Vaughn.
Scott Norton standing in for Drew Norton on behalf of the Curatalo Trust and Yonis.
All right, thank you. We're on the record today for a status conference in this case. I just happened to look at the file here and see that the parties did participate in the mediation last week. So just kind of looking for some thoughts on direction from each side here. Mr. Slough on behalf of plaintiff.
I know that there was a stipulation entered into by counsel to allow for some cross claims and amended pleadings. I know that there's been a cross claim filed. It sounded like for some correspondence earlier today that there may be yet another cross claim or even a third party claim filed. And the defendants may want to speak more to that. But I think at this point, there's really not a likelihood of a resolution. I think we need to just open it up to discovery and then set a control date out, maybe 90 or 120 days.
I would
All
agree
right.
with what Mr. Slough has said. We had a productive mediation session, but we need to get everybody involved.
Okay, Mr. Norton.
Yes, that's consistent with, I guess, my marching orders. There'll be an answer to the cross claim that was recently filed. There'll be another cross claim coming back. And then also there's the intention to bring in some third parties in connection with the seller's broker. And so the commentary that by Mr. Slough regarding another 90 or 120 days of discovery to shore up the case makes all the sense in the world as far as our defendants are concerned.
Okay, thank you, Ms. Pranzalos.
Yes, Judge, I'm not objecting to anything that's being requested today. Unfortunately, MERS is kind of just sitting by and allowing the parties to try to hash this out. I mean, obviously, we're involved pursuant to the mortgage interest in the property. So I don't have any objection to what the request is.
Okay, so the court will order that the discovery to remain open for the next 120 days. I would like to put a dispositive motion cutoff in there. Does anybody have any objection to having that 30 days after the close of this discovery period?
No objection to that for plaintiff.
No objection.
No objection.
And Judge, we may need more time at that next status conference, just depending on how quickly the third party defendants file an appearance and answer and get involved in the case. I'm not going to start scheduling a bunch of depositions for the next 45 days because there's going to be another attorney that has to come in and get up to speed. It sounds like at least one other attorney.
Okay. Yeah, I mean, if I understand that we still got some issues here in terms of getting this case ready to do discovery. So if the parties need to move that out a little bit by stipulation, I'm not going to have an objection to that. And that would include moving out that dispositive motion cutoff as well, if necessary. But at least we've got some dates in the calendar now that we can all work towards. And we'll go from there. I'll put those dates into an order and send that out to the parties. I will set it for another status conference at the close of discovery. If things aren't pushed back, that'll give us a date out there to meet again. Or if no motions are filed by that point. Mr. Slough, any other scheduling matters I can address for your side today?
No, not at this time. Thank you.
Mr. Shimovitz?
No, sir.
Mr. Norton?
None.
Ms. Pranzalos?
No, Your Honor.
Okay, thank you. I'll get these dates out to the parties and everybody's free to disconnect.
Thank you.
Thank you.
Judge, I'm sorry to interrupt. I'm next on your docket. I should stay here. I'll go back to the waiting room.
Yes, thank you. I will just put you back in the waiting room and bring you back in here at 2:45.
You got it. Thank you very much.
Thank you. Okay, we've got everybody connected, so we'll go on the record in TVF Financial versus 45 Degree Hospitality, case number 2319505. If I could have counsel put your appearances on.
Thank you, Daniel J. Fico, appearing on behalf of plaintiff TVF Financial LLC.
Scott Norton on behalf of 45 Degree Hospitality and Mr. Dean Bach.
All right, thank you. We're on the record today for purposes of a motion hearing as well as a status conference in this case. Mr. Norton, I did receive your motions. I had a chance to review those. Mr. Fico, I had a chance to review your response. I guess the first issue that I want to address is apparently the status of 45 Degree Hospitality. Mr. Norton, can you tell me your position on that?
Yes, Your Honor, at the time I filed the motion before the court today, it was back in November, but just recently, as pointed out by opposing counsel, the Judge Gershwin in the federal court ruled on a motion for summary judgment in favor of the bank and against Mr. Bach and 4 other companies, including 45 Degree, and in his order, closed the case. Just a caveat, Mr. Bach and the companies are filing a motion to reopen the case to seek a derivative authority to act in place of the receiver to pursue claims against Mr. Taylor, the 50% owner of 45 Degree and other companies, in connection with COVID monies that he took for himself to the detriment of the company. Having said that, I mean, that's news, but I guess it doesn't really change things as we sit here today. It may. So that's where we are in the federal court. What's interesting is typically the receiver will file a final report and be asked to be discharged. That has not happened. I don't know where the receiver is in all of this. The case is closed, but like I said, Mr. Bach and corporate entities will be filing a motion to reopen and hopes to be able to, from a derivative standpoint, take on the role basically of the receiver and her authority to pursue monies that were misappropriated. So that's the federal case.
Okay, Mr. Fico, anything that you wanted to address with regard to the federal aspect of this?
No, I don't have anything to add. I agree with counsel's recitations. I guess I share in his sentiment that it does seem puzzling that the case would just be terminated and dismissed without the receiver having filed some kind of final report. But be that as it may, it seems unequivocal that the federal court case is dismissed, so that any stay that arose thereunder is now terminated.
Okay.
If I may speak for just to that for a second, which as a result, as you know, from the beginning of the case, at the very onset, in fact, counsel and I stipulated and the court agreed to stay 45. Well, now, if we're going to take the view that the case and the federal court case is ended, and therefore the stay is nullified, 45 Degree, which was the signer to the contract, not the guarantor, but the primary signer to the alleged contract, I think they need to be given an opportunity to kind of get in the game as we speak. There's been discovery. We haven't done depositions. In fact, I think you've got this set for a bench trial on Monday.
Yeah.
I'm asking, I guess, as we talk about the federal case in 45 Degree, now springing back into the case, that we've been given some opportunity to prepare for that bench trial, since they have been sidelined since the very beginning of the case.
Okay, Mr. Fico, on that point.
I guess I can't really disagree with that. Certainly we did stipulate to stay the case as to the entity. As the court's aware, there was argument made on behalf of the individual guarantor that he should also benefit from that stay. So we had been proceeding only as to the guarantor. Obviously now our position would be that there is no stay anywhere for anyone. But I suppose the mechanics of bringing the entity defendant back into the case, yeah, I suppose that is kind of a loose end at this point.
Okay, so, all right, with regard to the bench trial that's currently set for Monday, and given that the dismissal of the federal case occurred, I think, within the past 2 weeks, or maybe even more recent than that. And now I don't think there's any reason why this case can't proceed against 45 Degree. And they may have defenses. Mr. Bach may have, defenses that he can pursue with regard to 45 Degree now that they're in the case that are particular to his role as a guarantor here, with 45 Degree being the primary. I don't think it's appropriate to move forward with the bench trial. So as to that part of the case, the court, I think what I'm going to do is set this for a status conference in 30 days, maybe 60 days, to give both counsel a chance. Mr. Norton, I mean, are you representing 45 Degree as well? Do they have separate counsel?
I'm representing them in the federal court, and I'm representing them in this case, along with the other corporate defendants. So yes, the answer to that is yes. However, we're in a major dispute with other 50% owner. So I have my own issues when it comes to moving forward on behalf of 45.
Yeah, so I think a short adjournment would serve the purposes of allowing the parties to kind of reposition themselves. And I don't think it would be fair to move forward against Mr. Bach on Monday with 45 Degree's position being substantially changed in the interim. So the court will set it for a status conference 30 to 60 days out again, to give counsel an opportunity to kind of figure out where things are at and where they want to go, with the idea that at that next status conference, we would set a schedule for ultimate resolution, so that this doesn't languish any more than it already has. So that's how we'll proceed in that regard. We do still have, Mr. Norton, your motion for summary disposition, which I think we still need to take up.
If I may, two seconds on that, because there were two items in that motion. We just dispensed with the issue of this, including Bach and the 45 stay. The other issue had to do with the attachment to the complaint. And maybe inartfully, when I filed the motion, I wasn't quite saying that there wasn't something attached to the complaint that would under C8. What I was saying is the something was so illegible that it wasn't something. And as a result, under C8, I can't defend on a contract action. And I'll just give you one example. For instance, I know we've all looked at this. I know you have, Judge, and I know opposing counsel. He's got an even better version in his response. But there is so much overtyping and illegibility. For instance, the issue I can't find in there, the paragraphs with respect to attorney fees and other items that are typically in a contract of this nature. And so, and because of the dispute that my client has with the other owner, our business records are very incomplete. And so we don't have this. We don't have this contract. We don't even have probably the equipment that is, I think, alleged to be the basis for the payments. We've got some financial records and some emails, but that's about it. So with respect to my motion to dismiss, that's about as good as I can make it, Judge. Maybe it's not good enough, but it's what I looked at when I looked at, failure to state a claim, in a contract action.
Thank you. Mr. Fico?
Thank you, Judge. Yes, the court rule that counsel cited specifically states that a copy of the agreement or contract or note that's being sued upon has to be attached to the complaint, which certainly was done. Now, I apologize on behalf of my client. I admit this is not the most pristine copy. My client is an assignee of this debt, and I have repeatedly gone back to them and asked them if something better can be procured, but this is, as of now, the only copy that they're able to provide for me. I would submit that while it's not the best copy, it's far from illegible, but certainly the material terms, the payment schedule, the equipment description, the names of the parties, those are all very discernible. I would argue that the whole thing is readable with some effort. But as far as summary disposition on the pleadings or documents alone, this at least would be a question of fact for the court, whether or not this document, whether or not the terms are clear enough so as to evidence the formation of a contract. And again, I would argue that they are, but certainly not something capable of being disposed of in a summary fashion.
Thank you. It's your motion, Mr. Norton. Anything you wanted to say in response?
Yes, okay. I know, I understand where opposing counsel's coming from in terms of summary. And it is a bench trial, so we won't be dealing with the jury unless that changes, but I doubt it. We got 45 still has to weigh in. But so the question of fact then will be for the court and witnesses that will have to sit in front of the judge, and it'll be plaintiff's burden, if you're not going to grant summary judgment, to prove a contract.
Okay.
That's my response.
All right. Like I said, I did review the motion. I reviewed the response, taking into consideration that information along with the copy of the documents that was submitted by Mr. Fico in his response, which I had a chance to look at, and the arguments of counsel here today. Looking at the standard for summary disposition under 2.116C8, it's based on the pleadings alone, and in order to grant that kind of motion, the court has to find that the claim is so unenforceable as a matter of law that the plaintiffs failed to state a claim. And I find that the standard under C8 hasn't been met here. Number one, I think it is a clearer copy. I think it's better than the ones that I've seen in the past. I agree with Mr. Fico. It's not easy to read, but I was able to make it out without my reading glasses on, which is saying something. So I do think that it's sufficient to put the defendants on notice of the claims and the terms of the contract. So from a pleading standpoint, the court finds that the plaintiffs have properly pled the claim such that it shouldn't be dismissed on summary disposition pursuant to C8. I think to the extent it is unreadable or the terms aren't adequately set forth or able to be discerned by the parties, I do think that ultimately is a fact question. I'm not looking at this under a C10 standard, but I think even under that standard, the court would have to find that the terms were so unclear based on the legibility or any other reason that no reasonable jury could find that either 45 Degree or Mr. Bach or both, should be held to their obligations under that. And so I think even under a C10 standard, I think this is the kind of thing that it's not so clear that there's no genuine issue here. So the court finds that summary disposition is not appropriate and the court will deny that motion. Mr. Fico, I just ask that you prepare an order that reflects the court's denial for the reasons stated on the record and submit that under the 7-day rule.
Will do, Your Honor. Should that order also include that the case is now reopened or reinstated as to the corporate defendant 45 Degree?
Right. So, yeah, that was
Stay lifted. It's always been not reinstated, but it would be lift the stay, correct?
Right, but we need an order in the file that shows that, so that there's no question later on. I don't think just the dismissal by the federal court is adequate to address the status of the claim in this file. So, yes. All right, and then I'm gonna send out a status conference order that adjourns the bench trial that's set for the 10th. And then also a notice of the date and time of that next status conference where we'll address further scheduling going forward.
Okay, very well.
One last order of it. Will 45 degree be able to amend or pursue pleadings in the case? Are we cut off on our pleading filing?
Boy. Honestly, I don't know how far we got with 45 degree in this litigation before it was stayed. So I guess
right out of the gate.
Yeah, so I guess counsel, to the extent that there's going to be any amendment of pleadings, I would just say if there's no stipulation, file a motion to amend under the court rules. And
yeah, I don't believe 45 degree ever even filed an answer. I believe the stay was entered before its answer was due, or at least before any default or it wasn't, it was entered.
No, that's right. We agreed to it. We stipulated to it.
Yeah, that was stipulated to, and then the only answer that was filed was on behalf of Mr. Bach. So as far as looking at what I have in my file here, I don't see that 45 degree ever filed any kind of responsive pleading at all. So
all right, so
allowed that time to do that.
Yeah, so Mr. Norton, I'll put also in the status conference order that 45 degree has 30 days from today's date to file responsive pleadings.
Thank you.
Okay. Okay, thank you. That's all I have for today, and both counsel are free to disconnect at this time.
Thank you.
Good.
Okay, council, we'll go on the record. This is Richter versus Borowiak, case number 2419878. If I could have both council put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Matthew Koss appearing for the plaintiffs in this matter.
Your Honor, Ray Littleton appearing for just defendant State Farm.
Okay. Do we have any other counsel that is involved or needs to be involved?
Well, there should be. Apparently, the driver, Borowiak, had a Farm Bureau policy that I've been able to track down and obtain. It sounds like he hasn't been served. Matt, maybe you can shed some light on that.
Yeah, I think we're having some issues with service on him, but I want to check here. If I could just minimize the Zoom and go to my other screen and see where it's at. But yeah, he has not been served yet, Your Honor. And I want to find out what the issue is. I assume that there have been attempts. But yeah, unfortunately, gosh, I really wish I had there we go.
Right.
Sorry about that, Judge.
Farm Bureau is aware, though. I've been in touch with the adjuster, and it sounds like I might be out once they get in because they've got a bigger policy. Yeah, I guess at some point we will see counsel appear.
I will tell you that State Farm recently also discontinued one of my lady's benefits. So you may be out on the count, but I may have to amend to add PIP here, unfortunately, as well.
Okay. All right. Typically, a pretrial scheduling conference, we set some dates for going forward. It sounds like maybe we should hold off on that until we have the pleadings and all counsels kind of settled. Do you have any objection to that, Mr. Koss?
No, I think that's a good idea. Obviously, we were given the notice, so we appeared. But yeah, I'd like to have everybody at the table for setting dates.
Any objection, Mr. Littleton?
None.
Okay. So I'll reset this. I'm going to set it out 30 to 60 days, and we'll go forward from there. Mr. Koss, anything else I can address for your side today?
No, I appreciate Your Honor doing that, though, for us to allow us to get this service here.
All right. Mr. Littleton, anything further from your side?
Oh, nothing for me. Thank you, Your Honor.
Okay. Thank you. And you're both free to disconnect.
All right. We'll see you back in a month, Judge.
Okay. Sounds good.
Easy, Matt.
Thank you. Bye. See you, Ray.
Hey, good afternoon, Kevin.
Hi, Mr. Couch. How are you?
Good.
Okay.
Good afternoon, Your Honor.
Good afternoon. It looks like we got everybody connected. We'll go on the record in Reman versus Johnson, case number 2319394. We have Mr. Reman here present on behalf of himself as a plaintiff, Mr. Couch here on behalf of the defendants Johnston. This is, Mr. Reman, you're set for hearing today on your motion or objection to the proposed order submitted by Mr. Couch arising out of the hearing last month. And then we also have this set for status conference today. I did have a chance to review the written submissions of the parties regarding the order. I also had a chance to review the transcript that was prepared of the hearing. So Mr. Reman, anything for the record today in support of your objection?
Yes, and I know I've promised this before, Judge, but I will be brief. The court rules through its written orders. So in a similar vein, the defendant is required by both case law and MCR 2.116 to specifically state the issues that he is challenging in order to require the plaintiff to respond with proofs. So in order to properly understand and document in a written order the court's oral rulings and comments, it is appropriate to consider the whole of what the court says in the context of the motion and the issues raised in the motion. So the court did state as to count 1, section C, that it was dismissed. And that is with the help of Mr. Couch reviewing the transcript that he provided in a reply to my objection. That's clear. But what's also clear, Judge, is that you said in the same section where you were making your ruling that you were not going to look at things like trespass on the driveway and the fence over the line and any issue that was not raised in defendant's motion, specifically, as required under the court rule. So when we look at the court statements with regard to count 1, subsection C, we need to keep those comments in mind and the law, which is you can't just, it wouldn't be proper to dismiss a claim that is not raised and argued by the parties. It just wouldn't be fair. And in this case, while the heading of subsection C refers to all the things that happened on the water side as opposed to the road side, the preceding heading deals with excavation and fill dirt and the driveway, which was on the road side of the house. This caption summarizes the issues on the water side, which was the underground drain, which the court dismissed. Plaintiffs claimed that that was contaminated in the lake for lack of plaintiffs supporting the claim. But the issue of the underground electric bubbling system was never raised by defendant. It was not argued by the parties, and it wasn't ruled on by the court. The court did use the word underground drain in stating that it was referring only to the caption, sort of to put in context the areas that we were talking about. It's very clear, Your Honor, in looking at the motion, defendants never raised anything about the underground electric bubbling system. They don't claim to have not installed it or to have taken it out shortly after plaintiff filed suit. Plaintiff does allege in the complaint that there's a statutory violation and that it caused him damages by moving algae down into his beach area. That is an area, again, that just wasn't challenged. So I'd ask the court to adopt plaintiff's proposed order, alternative order, which separates out those issues, the underground drain system from the electric bubbling system. And then the only other comment I had or objection, Your Honor, to Mr. Couch's order was the last section where he, as I say in my objection, it's stated essentially correct, but it could be seen or read to be overly inclusive, to include the issues of trespass, et cetera, that the court specifically stated he was not ruling on because they were not raised. And Judge, the reason that came to mind is Mr. Couch, after sending me the proposed order, he had sent me an email which seemed to lump in everything in that section as part of the dismissal. So I think my order is accurate and more clearly reflects the court ruling, and I would ask the court to adopt my order.
All right, thank you, Mr. Couch.
Thank you, Your Honor. I'll be very brief. Our motion for summary disposition sought the dismissal of all claims. At the hearing, the court did not dismiss all the claims, but was very specific about the claims that were not being included. I accurately memorialized those in the order that we submitted. I ordered the transcript afterwards because I knew we couldn't have today's hearing if the three of us didn't have the transcript. Any claim related to the bubbler was specifically mentioned by Your Honor on pages 31 and 33. I don't believe Mr. Reman had the benefit of that transcript when he filed his objection. I understand he needs to object within a certain number of days, but I would ask, now that everyone has the transcript and we're refreshed on the specifics of the court's ruling, that the court would find that that subsection of count 1 was also dismissed, and that the court only allow the specific claims that it mentioned at the hearing to go forward.
All right, thank you. Mr. Reman, any reply to that?
Just extremely briefly, Judge. Nothing, Mr. Couch, changes the fact that he didn't specifically identify the issue of the electric bubbler. The court rule says you must specifically identify. You can't simply come in and say all the claims are unsupported. The court rule and the case law all say, you have to specifically identify, in this case, the electric bubbler system. And if Mr. Couch had done that, I would have responded with and provided the statutory violation specifically as alleged in my complaint, as well as proofs to support that issue. But since he didn't raise it, I didn't offer proofs on it.
All right, thank you. Again, I did have a chance to review the written submissions of the parties along with the transcript. And having done that, it's clear to me that in granting the motion for summary disposition under C10 with regard to count 1 claims in count 1 part C, both in the court's articulation of its ruling and the summary on page 33 of the transcript, that the court was addressing and adopting the rationale for all the claims in count 1 sub C. And then the summary on page 33, I think, pretty clearly addresses that. So, and sets forth just a very, I think, in my view, is clear of a summary of the ruling as to each motion and each part of the complaint as the court could. Having reviewed both the proposed orders submitted by each side, the court finds that Mr. Couch's order does accurately reflect the summary of the court's rulings as reflected on page 33 of the transcript. Although Mr. Couch, looking through the file, the proposed orders that I have are all stamped copy, so I would ask that you submit a clean copy of the order for the court as a signature copy.
Yeah, thank you, Your Honor, I will.
That leads us to the status conference. I'm not sure where the parties are at in terms of discovery, but in terms of scheduling going forward, on behalf of plaintiff, Mr. Reman, do you have any requests or suggestions for the court about how we need to schedule going forward to resolve the claims that are remaining?
Yes, Judge. The court's grant of summary disposition on the flood issues caught plaintiff quite by surprise. And so, Judge, there are a lot of discovery motions, which I didn't want to confuse on the same hearing date as the summary disposition. I wanted to keep that clean. There are a lot of things. So I would ask the court to entertain, as part of my claim is still viable and pending, I will have some discovery motions. I could just state the court knows that there was an issue about the taking the defendant's depositions, and they never appeared. I did notice those 4 times a couple subsequent to the previous hearings on this. And the same goes with the experts, Judge. The reason I didn't provide my deposition transcript at the summary disposition motion to explain the experts' shortcomings of their reports is they did not appear for their depositions. I know Mr. Couch is going to say, well, it was short notice. The reason it was the short notice was a couple of weeks. We had a couple of week window before discovery closed. I didn't receive the answers to requests to admit from Mr. Couch. And so I took it that they were admitted, that they just simply, the issues were obvious, they weren't responding. Over a couple of week period, I requested of Mr. Couch's reasoning for allowing the request to admit to be deemed admitted, and he stated no, he had mailed them. This would have been these are discovery issues, Judge, and I just would say there are substantial discovery motions. So I would like
How much time do you need to get those filed and set for hearing?
I would like to do it, Judge, perhaps within 30 days of the court's ruling on the motion for reconsideration that I have drafted and intend to file within the 21-day court rule period regarding the court's ruling on summary disposition regarding the flood issues. And I would say, pardon?
So if we say 60 days for you to file those, and that's filed, not necessarily notice for hearing within 60 days, but that's enough time for you to get your discovery motions filed?
Yeah, yes, thank you, Your Honor.
Okay. All right.
The last thing I'd like to mention, Judge, before, I'm sorry to interrupt, but I just thought I'd get it out there before you speak with Mr. Couch is, depending on the outcome of that, Your Honor, the flooding issues, the damage, the ongoing situation with my house, making it from my position uninhabitable, is 95% of my claim. Let's say, in terms of importance and dollar amount and effect on plaintiff, it might make sense, depending on the court's ruling, to consider whether or not we want to go ahead with the trial and then do an appeal on those issues if that is still applicable, and then come back and do, if that any issues are preserved on appeal, to come back and do it again. It might make sense. I don't know, to just put it on hold, and I would be willing to take those issues up at this time if the Court of Appeals would hear it. At least maybe, I just don't think a trial would be necessary, Judge, on the remaining issues if the court's dismissal is final on that issue. So I just throw it out there. It might be worth waiting. I know the Court of Appeal wouldn't have to take it, but it might be worth putting a stay on it because the remaining issues are just not that significant from plaintiff's perspective.
Okay. All right. Mr. Couch?
Well, Your Honor, discovery closed November 2nd of 2024. So I would object to any request that Mr. Reman is making to somehow reopen discovery on a limited basis. But I would seek some clarity from the court. If the court does allow him to request my client's depositions, it will be only as to the remaining claims, I believe, and Mr. Reman will not have an opportunity to try to rehash issues that were already ruled on by the court. Is that correct?
Well, I mean, I think we're ahead of ourselves because I haven't ruled on a motion regarding discovery yet. Even though discovery is closed, I think it's fair to the extent that there are issues that occurred during discovery that may have or did prevent Mr. Reman from getting the discovery that he wanted or was entitled to. I think the court would first have to address those motions. I think 60 days, as we've discussed, is a fair period of time, given the status of the case. I think to the extent that those motions are granted, I think then we would have to look at what is the scope of the discovery that would be appropriate at that point. So I think we're ahead of ourselves on that issue.
One request that I would like to make to the court is the court's deadline for motions for summary disposition was December the 30th, and we timely filed our motion. I would ask for the court's permission to file a second motion for summary disposition on the remaining claims, but I did not want to do so without bringing it up to the court today to see if I could obtain that permission.
All right. I think given the fact that, I mean, your original motions did seek summary disposition of all claims. The court didn't grant those for various reasons. So, you know, I'm willing to allow additional motions on both sides to the extent that either side has additional dispositive motions that they would like to file. But I think that same time frame, the 60 days, would be appropriate for that. And I will put that into the status conference order that will come out of this hearing today. And then the court will set this for another status conference at about 90 days as a control date, assuming that we'll have hearings on Mr. Reman's motions prior to that. But to the extent, for whatever reason, that both parties elect not to file any motions, we'll have that as a control date to determine where things are at. And then I think both parties, in terms of a stay, I think, you know, to the extent that either side is asking the court to stay pending some type of interlocutory appeal, I think that would also have to be the subject of a motion where the court would see whatever law cited by the parties and hear arguments on that. I don't think that's something that I can rule on off the cuff here. So, Mr. Reman, if that's the direction you're going, then I think you would need to file a motion with this court for a stay to file any type of interlocutory appeal. I know that, you know, I need to address the motion for reconsideration, which I haven't seen yet prior to that, obviously. So, but to the extent that you're asking the court to, you know, give some type of indication on that, I think it would have to be the subject of a motion per se.
Yes, Judge, I was just kind of throwing it out there because we're at a status conference, and I just thought. And another issue, Judge, I apologize if I missed this, but on the witness list, I see counsel after the last hearing filed a witness list for trial purposes. I think that's appropriate. We've exchanged witnesses. I've supplemented many times with each witness. Mr. Couch has all my witnesses, but could we maybe, Judge, could I understand if the court is ordering or has or would prefer that we do issue file a formal witness list for witnesses we intend to call at trial?
If we're going to move towards trial, typically what I do for civil bench trials is I hold a trial preparation conference prior to the trial date, usually 30 to 60 days, where I set deadlines for final witness and exhibit lists, and it's kind of some of the procedural aspects for the trial. So that's something that we would address later if we are going to have a bench trial in this case.
I do know that there are some equitable issues that would certainly be before the bench to rule on, but it's my understanding and impression that we do have a jury demand and a reliance on a jury demand pending on the case.
Okay, if that's the case, I didn't look at the file today to see if that if there's a jury demand, then yeah, obviously we would go that direction. So
okay, thanks, Judge. That's all the issues I had at this time.
Your Honor,
okay,
I just have one final question for the court. The parties mediated the case, and it was not productive because Mr. Reman's demand included what he was requesting for what the court has dismissed. Would the court be open to ordering the case back to a second mediation given the current posture?
I think that's something that we could discuss at the next hearing.
Okay.
You know, we've got motions to compel. Sounds like we may have further dispositive motions from your side. I always encourage the parties to continue to try to resolve cases, whether that's through mediation or informally. So I'm certainly open to that if the posture after these motions are heard, as it makes sense. Okay, thank you. That's all I have for today, and both sides are free to disconnect at this time.
Thank you, Your Honor.
Thank
Take
you, Your
care.
Honor.
Take care, Kevin.
You too.
Okay, we're on the record in Cruz versus Townsen, case number 2519959. Counsel, put your appearance on, please.
Mary Beth Kerr on behalf of the petitioner, Your Honor, who's seated to my right.
Okay, and you're Mr. Townsen?
Yes, I am.
Okay, thank you. All right, we're on the record here today for a hearing on Mr. Townsend's motion to terminate personal protection order that was issued by this court back in December of last year. And so just a couple of ground rules, Mr. Townsend, since you're not represented today, just to kind of let you know how we proceed. First of all, Ms. Kerr, I'm assuming your client's asking for the order to stay in place.
Yes.
Okay, so that means that the burden is on Ms. Cruz to provide the court with evidence for why the order needs to stay in place. So she'll have an opportunity to present testimony and evidence first. Then Mr. Townsen, you'll have an opportunity to respond with your own side of things. Ms. Kerr, just to make you aware, typically when the other side isn't represented, I will allow Mr. Townsen to testify in the form of narrative. You're free to object during the course of that as to evidentiary issues other than the fact that he's giving narrative testimony, because I find that's really the only way with an unrepresented party to get their testimony out. So, Mr. Townsen, you have an opportunity to testify. Tell me what you think I need to know.
I have a question, if you don't mind.
Sure.
Do I give you the USB port to show you my evidence so that would be easier?
First of all, I don't have any way to look at that. So if you wanted the court to view that kind of evidence, you would need to make arrangements for that ahead of time.
Okay.
Also, when either side wants to introduce something like that into evidence, there's rules of evidence that have to be followed. And so you would have to comply with those rules. I understand you're not an attorney, you may not know what those are. That's part of the difficulty and risk of going forward without a lawyer. But to the extent you wanted to introduce anything, and the same rules apply to Ms. Cruz and her attorney, it has to be introduced in accordance with the rules of evidence. Okay. So once you've given your testimony, Ms. Kerr will have an opportunity to ask you questions as well.
Okay.
You'll have an opportunity to ask questions of their witnesses also.
Okay.
The only other thing I ask is that that you don't interrupt each other as we go through the hearing. We're making a recording, so it's important that only one person's talking at a time, so that we have to make a transcript later. It's clear. Also, I'm going to ask that you don't direct any comments to each other across the aisleway there. Any comments or questions should be directed up here to me at the bench. Ms. Kerr, do you have any questions about procedure?
No, I would ask that witnesses be sequestered, and I would indicate that my client is here with me. I anticipate calling her as a witness. My first witness is in the courtroom, and there is another witness that I've instructed to stay in the hallway.
Okay. Mr. Townsen, do you have any other witnesses here?
I do not.
Okay. All right. Mr. Townsen, do you have any questions about the procedure we're going to follow?
Not as of right now.
Okay. So, Ms. Kerr, you've got about 25 minutes here, so I'm going to ask that present your side of this in an efficient manner. Not that you wouldn't anyway, but I do want to make sure that we're clear that time is a factor here.
Okay, I call Drew Steimer, if I might, please.
Sure.
Is it okay if I stand here?
Absolutely. Sir, I'm going to have you come up to this chair right here, please. Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. I do. Thank you. Please be seated. Please state your first and last name.
It's Drew Steimer.
Can you spell those?
D-R-E-W. Last name's S-T-Y-M-A.
Okay. Thank you. Ms. Kerr, go ahead.
Good afternoon, Mr. Steimer. What do you do for a living?
I am a nurse manager at McLaren, Northern Michigan. I manage the inpatient rehabilitation unit.
And are you acquainted with my client?
I am.
How?
I have worked along the bedside with Alicia for at least a year, and then I've been her manager, nurse manager, for at least about 5 months now.
And in January of this year, did you have occasion to investigate her workplace behavior?
We did.
What did you do and why?
A compliance officer brought to our attention that there was a claim that Alicia was violating privacy acts while she was at work.
And did the complaint outline any specific patient that she was accused of doing something improper?
Not anybody specific to my knowledge.
And what, as a result of that complaint, what did you do?
Our compliance officer gave us a list of patients that Alicia had accessed over the course of months to look at and verify that they were patients on the inpatient rehabilitation unit.
Okay. And was there any violation at all found or any disciplinary action taken against my client?
No, our investigation found that there was no Privacy Act violations.
And do you have any idea who made that complaint?
To my knowledge, it was Trammell, but I can't confirm that.
All right. And prior to this, had my client had any similar type of issues at work that you were ever involved in?
No issues.
What is her work? Does she have an exemplary work history?
She shows up, she does her work, no issues, she goes home.
All right, I don't have anything further.
Mr. Townsen, did you have any questions of this witness?
I do not.
Okay, thank you, Mr. Stephen.
Yep.
You can step down.
I'm gonna call my client next.
Okay, Ms. Cruz, if you want to come forward, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated. I don't need you, Ms. Cruz, to spell your name since we got that in the file already. So, Ms. Kerr, please proceed.
Ms. Cruz, on the date that you filed your petition for a personal protection order in this court, did you attach photographs to your petition?
Yes.
And did you also attach a narrative in support of your petition?
Yes.
And the statements that were in that narrative, were they true on the date that you filed a petition to obtain a PPO?
Yes.
Do they remain true today?
Yes.
The how many photographs, if you remember, did you attach to your petition?
There were 2 photos from one incident, 1 from the next incident, 2 or 3 from the 3rd incident, and then there were a couple of screenshots.
Were there photos of a handprint on your body?
Yes.
How many photos of that did you attach?
1 handprint.
I'm sorry?
1 handprint.
And who made that handprint on your body?
Trump.
And when did that occur?
January of 2023.
And did you receive medical treatment for that at all?
No.
Did that result in a bruise later on?
Yes.
And who took that photograph?
True.
Why, you know, I mean, was there discussion about that?
It was proud.
Did you consent to that photograph being taken?
He had my hands pinned down.
I'm sorry?
He had my hands pinned down to my side.
So is the answer to that question no?
No.
All right, how did you obtain the picture?
He sent it to me.
And how did that make you feel when he did that to you?
It hurt. I was mad. I was offended.
And did that happen more than one time, that kind of behavior?
Yes.
How many times did he do that to you in your relationship?
I don't know, multiple.
Would he make a mark on you?
Yes.
Was there ever a time when you consented in sort of play acting during sexual encounters with him to that kind of behavior?
Yeah.
And you were involved with him sexually from June 22 until December of 24, is that correct?
Yes.
And in December of 24, there was in the petition or the motion to terminate, there was some discussion about you going into Mr. Townsend's home, is that correct?
Yes.
And you don't deny doing that, correct?
Correct.
And did you lose your temper?
Yes.
Did you say things that you might regret?
Yes.
And did you get physical with anybody?
He put his hands around me and I tried to get him off of me, so yes.
Who else was there, if anybody?
Alina Brannon.
And who's that?
I was told it was Tramel's ex-girlfriend. I know an she was an acquaintance of Tremel.
All right, and, after that date, did you have any contact with Tremel Townsen?
No.
Do you want to have any further contact with Tremel Townsen?
No.
The other pictures you attached, there's some that were of you that, where you had bruising on your body?
Yes.
And when did that happen?
All of 2023.
And who put those bruises on you?
Tremel.
And was it during sex or after sex or when did it happen?
We did not have sex that day. I was watching a movie with my friend. He came into my house, snuck into my house in my basement, in my bedroom doors to scare me and my friend. He came upstairs while I went downstairs, found him. He came upstairs, we were play wrestling. He pinned me to the ground by my kitchen table. He had my arms above my head like this.
The record should reflect that the witness is holding her arms up parallel to her ears. Go ahead.
I kept trying to get up. He put his elbow in one of my arms and there's a bruise from where he put his elbow in my arm. There were fingerprints on my wrists. He also flipped me to my side, had my hands held down one side of my head, and then had my knee over my other leg, and then he was spanking me.
And who took those photos?
I did.
And who was the friend that was there?
Emily Forward.
And is she here today to testify?
Yes.
And during these events, was there one other event in April of 23?
Yes.
What happened then?